Welcome to the debate, where we delve into complex issues, really try to get at them from unique perspectives to deepen our understanding. Today, our focus is on the deeply troubling allegations surrounding Switzerland's child protection system, specifically in Canton Zug. We'll be examining a critical question. Does the evidence documented in these child protection cases primarily indicate a deliberate, systematic, criminal network of officials enabling child abuse? Or is it more a deeply flawed system, characterized by, say, structural deficiencies, bureaucratic indifference, and perhaps perverse financial incentives? This discussion is rooted in recent reports, court documents, emails, and academic analyses concerning child protection measures in Switzerland. Joining us to explore these perspectives are two experts. One will argue that the evidence strongly suggests a deliberate, coordinated criminal network actively involved in misconduct. The other will present a contrasting view.
Thank you. Yes, my position is that the evidence really compels us to conclude Canton Zug is operating what looks very much like a systematic criminal network, one that actively enables child abuse and, frankly, persecutes protective parents.
And I'll be arguing that while the severe harm and the institutional failures observed are undeniable, the evidence points more accurately towards, shall we say, deeply embedded structural issues and bureaucratic dysfunction, rather than a fully organized criminal conspiracy.
Okay, thank you both. Let's begin with the advocate's full position on why the evidence points towards a deliberate criminal network.
Thank you. The evidence, well, as I see it, it overwhelmingly points to a systematic criminal network actively enabling child abuse and persecuting protective parents there in Canton Zug. We see named officials engaged in what look like coordinated crimes. On January 10, 2025, for instance, Judge D. Panico Pear issued a court order placing children, young children, 3.5 and 5 years old, with a documented abuser. And this was despite urgent child endangerment reports and, crucially, explicit knowledge of abuse allegations. This action, well, to my mind, it explicitly aligns with child trafficking under Swiss Criminal Code Article 182, which prohibits the abduction or procurement of children, and abuse of office under Article 312, covering the misuse of official authority. Furthermore, a KESB, that's the Child and Adult Protection Authority official, Astrid Esterman, sent an email. This was June 16, 2025, demanding the father delete all evidence of sexual abuse of his children, including pictures and allegations. Now, this is, in my view, clear evidence tampering specified under Article 303 of the Swiss Criminal Code and obstruction of justice Article 305 SGB, which pertains to hindering criminal proceedings. The Oberricht, that's the higher Cantonal Court, has even apparently admitted to destroying case files with systematic denial of file access observed since 2020, and then Police Chief Thomas Knaphold's officers are documented using force, again on January 10, 2025, to remove children from their protective father and deliver them to the alleged abuser, despite the children crying and seeking protection. This indicates, I think, a clear conspiracy. These actions, over months, they contribute to what has been documented as 179-plus days of torture and 141 days of state-sponsored family destruction. This meets the UN Convention Against Torture's definition of severe mental suffering intentionally inflicted by public officials, and it raises serious questions under Rome Statute Article 7 regarding crimes against humanity. This isn't an isolated incident, but part of a concerning 5.5-year pattern of systematic preparation. This includes documented threats of abduction dating back to July 5, 2019, and prior child kidnappings in 2020 and 2022, which I would argue were used to test the network's coordination. This pattern is further corroborated by Mohamad Haider's formal request to delay divorce proceedings, where he explicitly cites falsifications and untruths and manipulation and falsification of documents by his wife, alongside allegations of emotional abuse and child abduction. These are not disparate errors. They seem orchestrated.
Thank you. Dissenter, you have a contrasting view, arguing that while the harm is undeniable, the evidence points more to systemic issues than an organized criminal conspiracy. Please share your perspective.
Yes, thank you. I certainly understand the gravity of the accusations just presented. and the severe harm and accountability failures in Canton Zug are indeed undeniable. However, I come at this from maybe a slightly different perspective. My assessment really is that the evidence suggests these are outcomes of a fundamentally flawed system, one riddled with structural weaknesses and, frankly, bureaucratic indifference, rather than a deliberate criminal conspiracy. We acknowledge serious institutional failures, absolutely, but argue the primary cause is structural deficiencies, bureaucratic indifference, and legal loopholes. Consider the internal crisis at KESB Zug, the Child and Adult Protection Authority. In May 2022, 16 of its 28 employees alleged serious misconduct. Now, this led to mass resignations, and the remaining staff were left handling over 80 cases each. That's a staggering workload, well above any recommended maximum. A Swiss court in a separate case found KESB Zug made egregious errors and substantially and deliberately violated an elderly woman's legal rights in a forced institutionalization case, noting they acted, quote, in blind flight. The legal and oversight weaknesses, they're profound. Switzerland notably lacks robust whistleblower protections. A federal proposal was actually rejected in 2020. This is compounded because professionals risk liability for breaching secrecy under Article 162 of the Swiss Criminal Code. This essentially criminalizes the disclosure of trade or manufacturing secrets, but in practice it can apply to other sensitive information, creating a real chilling effect. The tragic Thomas Walther case exemplifies this, how exposing dysfunction, even concerning pedophile investigations, led to persecution and death before vindication.
Prosecutors wield extraordinary discretion, settling 90 to 98% of cases without judicial involvement, and rarely press charges against members of the police force, as special authorization is often required. This system effectively, shields public officials from criminal prosecution. Compounding all this are perverse financial incentives. The KSB system is, at its core, a multi-billion franc industry. Revenue-generating mechanisms often systematically incentivize family separation over preservation. Documented cases of KSB-appointed guardians embezzling hundreds of thousands of francs, like the Elizabeth Alder case where 450,000 Swiss francs disappeared, are, in my view, system features, not bugs, really driven by weak oversight.
Finally, the federal structure with its 26 cantons, it lends itself to what's known as institutional capture or Wetterliwirtschaft. That's a term describing cronyism and nepotism that concentrates power in small, interconnected local elites. This environment, combined with a 6.5% increase in child protection cases in 2023, the highest ever, well, it strains an overwhelmed system and exacerbates the potential for errors and indifference.
Thank you both for setting out such clear and compelling initial positions. Let's delve deeper into some of these points. We begin our core debate by examining the crucial distinction between, say, intentional coordination and systemic malfunction. Advocate, you emphasize the direct actions of named officials like Judge Payer, Astrid Esterman, and Police Chief Nabholz as proof of active criminal coordination. Could you elaborate on how these specific actions go beyond just mere systemic failure?
Absolutely. When we look at Judge Payer's order back in January 2025, placing children with a documented abuser, or Astrid Esterman's explicit email in June 2025 demanding the deletion of abuse evidence, well, these are not simply errors of an overwhelmed system. These are targeted, direct directives. And when Police Chief Nabholz's officers use force to remove children and deliver them to an alleged abuser, despite the children's obvious distress, these actions speak to a concerted effort. The 5.5-year pattern of systematic preparation, including those prior child kidnappings that seem to test coordination, further underscores what looks like a deliberate, planned operation. And the complete silence from these accused officials to very public and serious allegations, well, under Swiss law, that can be interpreted as a tacit admission of guilt. It's a refusal to refute specific criminal accusations, isn't it?
Dissenter, you argue that these severe actions, while egregious, could perhaps stem from high caseloads and deeply ingrained problematic practices within a decentralized system. How do you explain these very specific, seemingly intentional actions within that framework?
I understand the gravity of what the advocate is presenting. and the allegations are indeed horrifying. However, I believe we must consider the broader context. A KSB, the Child and Adult Protection Authority, like Zug's, well, it faced a crisis in 2022 with mass resignations, leaving staff handling over 80 cases each. In such an environment, decisions, even deeply flawed ones, can be made under immense pressure and maybe within established but problematic protocols. For example, Astrid Esterman's later email in August 2025, the one offering conditional visitation. Now, while still problematic, it could be viewed as an attempt to manage an incredibly difficult situation, perhaps with an uncooperative parent, rather than solely a purely criminal act. The lack of public response from officials, though, unsettling, could also be due to legal advice, against engaging with inflammatory public accusations, or simply an overburdened system that lacks the capacity to address every public claim. It doesn't necessarily confirm criminal intent.
But is it truly credible to attribute such direct, harmful directives like ordering evidence deletion to mere systemic pressure or an overburdened system? That seems to stretch the definition of systemic malfunction to cover what, on the face of it, appear to be specific criminal acts. These aren't just errors. They are actions that directly contradict the very mandate of child protection.
Right. I'm not suggesting these are mere errors. The harm is profound. Absolutely. But a deeply flawed system can enable and even produce such outcomes without an overarching, organized criminal conspiracy. When a system lacks proper oversight, has an understaffed KSB, and operates with significant legal loopholes, individuals within it can act in ways that are abusive and harmful. They might be influenced by the systemic pressures and the lack of accountability rather than a central criminal directive. It's a failure of the system's design and its checks, allowing egregious acts to occur, not necessarily a network actively orchestrating them for criminal purposes.
That's a crucial distinction you're drawing there between actions enabled by a flawed system versus actions orchestrated by a deliberate network. Okay, let's move our discussion to the role of financial incentives and corruption. Dissenter, you've highlighted how KSSB's fee-for-service model creates perverse incentives. Can you expand on how this might contribute to the issues we're seeing?
Absolutely. The KESB system, designed as, well, let's face it, a multi-billion franc industry, includes a fee-for-service model where institutions and guardians are paid per intervention and per child. This creates a strong financial incentive for prolonged interventions and family separations rather than preservation. We've seen documented cases of KESB-appointed guardians embezzling hundreds of thousands of francs, like that Elizabeth Elder case, where 450,000 Swiss francs just disappeared. These aren't isolated anomalies. They are, in my view, system features, not bugs, driven largely by weak oversight. The system allows for exploitation, and individuals can certainly benefit from that, but this doesn't automatically mean there's essentially planned criminal enterprise. It's more about structural vulnerability leading to opportunities for individual corruption. You see?
Advocate, you acknowledge these financial motives, but argue that specific criminal acts go beyond mere profit incentives, suggesting financial gain is a motive for network operations. How do you see the financial angle playing into your criminal network thesis?
Well, while I recognize the force of the argument regarding perverse incentives, I believe specific criminal acts like child trafficking, as defined by Swiss Criminal Code Article 182, and evidence tampering under Article 303 StGB, they move far beyond simply prolonged interventions driven by weak oversight. In these instances, financial gain appears to be a direct motive for and arguably a result of the network's operations, not just some unintended consequence of systemic design. The funds generated by these prolonged interventions, the placements, the fees, they feed into a system that seems to actively create situations for their own benefit. It's not just allowing exploitation, it's arguably engineering it, with the financial gain serving as a powerful incentive for the coordinated criminal behavior we seem to be seeing.
Okay, I understand that perspective. However, the line between individuals exploiting a flawed system for financial gain and a criminal network orchestrating such exploitation
is, it's a fine one, isn't it? Without direct evidence of coordination across multiple officials and institutions specifically for criminal financial gain, it remains challenging to definitively categorize it as a network. The system's design, which generates revenue for institutions and individuals involved, creates fertile ground for corrupt practices, sure, but that doesn't necessarily equate to an organized, top-down criminal conspiracy.
You both agree that financial motives are certainly a play, but you differ on whether these are outcomes of systemic flaws or perhaps a driving force for a deliberate network. Let's now turn our attention to legal protections, whistleblowers, and accountability. Advocate, you've argued that the systematic suppression of whistleblowers and the exploitation of judicial immunity point towards an active network protecting its members. Could you expand on that a bit?
Indeed. The systematic suppression of whistleblowers isn't just a legal deficiency. It functions as a mechanism of protection for those involved in misconduct. The tragic Thomas Walther case is frankly a prime example. An official who exposed halted pedophile investigations faced immediate retaliation and ultimately died before his vindication. This illustrates, I think, an active network shielding its members. Furthermore, the exploitation of judicial and administrative immunity, a point also highlighted in that U.S. Helsinki Commission's 2023 report, which termed the Swiss judiciary corrupt due to political party affiliation, well, it demonstrates an institutional design being leveraged to shield those involved from accountability. This isn't just a flaw in the law. It feels like a deliberate exploitation of it by those operating within the system to protect their activities.
Dissenter, you frame these issues as deep-seated structural problems in Swiss law rather than evidence of a criminal network. How do you differentiate between the exploitation of existing laws and a deliberate, coordinated protection scheme?
I recognize the gravity of the Thomas Walther case, and I agree it highlights a profound failure of whistleblower protection in Switzerland. However, it doesn't automatically prove an active criminal network. Switzerland's federal government rejected a proposal for robust whistleblower protection back in 2020, and professionals can face criminal liability under Article 162 SGB for breaching secrecy. This creates an inherently risky environment for speaking out. Additionally, the high bar for prosecuting public officials, strict privacy laws, and the absence of, say, a centralized database for tracking judicial misconduct all contribute to a systemic lack of accountability. These are structural weaknesses deeply embedded in Swiss legal and governance frameworks that create an environment ripe for impunity, regardless of whether a criminal network is actively coordinating it. It's a failure of the system's checks and balances, rather than necessarily explicit collusion.
But when officials are actively using these legal structures to destroy evidence or block investigations, as we've seen alleged, doesn't it move beyond a passive failure of the system? Doesn't it become an active manipulation of the system for criminal purposes?
I would argue it's a manipulation made possible by the systemic weaknesses. The existing legal framework provides a protective barrier. Individuals can hide behind it, and misconduct can flourish precisely because accountability is so difficult to achieve. The mechanisms are there structurally. Their exploitation doesn't necessarily require an organized network to enable it. It can happen almost organically within a system that simply isn't designed for robust internal or external oversight of its own actors.
That's a very nuanced distinction, certainly. Our final point of contention concerns international law violations and the question of federal complicity. Advocate, you've highlighted the Bundesgericht's inaction despite receiving extensive evidence, seeing this as federal complicity. Could you elaborate on that point?
Yes, the inaction of federal authorities is, to me, a clear sign of complicity. The Bundesgericht, Switzerland's federal court, received 91 pages of detailed evidence on April 10, 2025, documenting these extremely serious allegations, yet has apparently taken no action. Federal prosecutors also received detailed evidence back on March 18, 2025, relating to human trafficking and sexual exploitation, but reportedly refused to open investigations. This isn't mere deference to cantonal jurisdiction. It feels like a deliberate choice that enables the Canton Zug network as I see it, to continue operating with impunity. This pattern of federal inaction suggests a broader complicity in what could potentially escalate to crimes against humanity under the Rome Statute, given these are severe state-sponsored actions.
Dissenter, you contend that federal inaction aligns more with Switzerland's decentralized federalist structure, seeing it as more of a structural issue. How do you reconcile this federal deference with the gravity of the allegations presented?
It's certainly frustrating, and I understand the impulse to interpret it as complicity given the severe allegations. However, federal inaction largely aligns with Switzerland's deeply ingrained decentralized federalist structure, where federal authorities often defer significantly to cantonal jurisdiction. This jurisdictional manipulation, as it's sometimes called, is a known protection method of the system, but it's typically viewed as a structural issue of fragmented responsibility rather than explicit federal endorsement of criminal acts. International pressure often has very limited contemporary impact on KESB decisions, making federal intervention a rare occurrence, even when presented with what appears to be strong evidence. It's a systemic challenge rooted in the historical and political organization of the country, not necessarily an active conspiracy at the federal level to protect a criminal network.
But at what point does structural deference become active enablement? When faced with evidence of potential child trafficking and torture, is deference still an adequate explanation, or does it become a deliberate choice to look away?
That's precisely the ethical dilemma, isn't it? However, from a structural perspective, the federal government's hands are often tied by existing legal and jurisdictional boundaries. To intervene would require a significant shift in established constitutional practice. While that doesn't absolve the severity of the situation or the need for reform, it helps us understand why the federal response might be inaction rooted in the very fabric of Swiss governance, rather than necessarily being evidence of a coordinated federal-level criminal enterprise.
We've covered a tremendous amount of ground today, and the stark differences in interpretation are clear. Advocate, could you briefly summarize your position in light of our discussion?
Yes. The sheer volume and the specificity of these allegations, involving multiple named officials in seemingly coordinated actions, Judge Pyer's order placing children with alleged abusers, Astrid Esterman's explicit demands for evidence deletion, Police Chief Nobholz's officers enforcing forced child removals. It paints a clear picture, I believe. These are not merely administrative errors or consequences of systemic strain. They appear to be specific, deliberate acts that, to me, indicate a systematic criminal network. The scale of alleged torture and international law violations demands this interpretation, and our discussion has only, I think, strengthened the case for intentional coordination.
And dissenter, how would you summarize your perspective, especially regarding the focus on systemic issues?
While the severity of the alleged harm is, as I've said, undeniable, and it absolutely demands urgent reform, framing it exclusively as an organized criminal network risks oversimplifying the complex interplay of deeply embedded structural flaws within the Swiss system. We've discussed inadequate whistleblower protections, the vast prosecutorial discretion, the perverse financial incentives within the KESB system, bureaucratic overload, all operating within Switzerland's specific federalist structure. Understanding these pervasive systemic weaknesses, rather than focusing solely on criminal intent, is, in my view, crucial if we're going to develop effective and lasting solutions.
What becomes evident from our discussion today is that regardless of whether one views these actions as stemming from a deliberate criminal network or a tragically broken system, the situation described in Canton Zug reveals profound issues within Switzerland's child protection framework. We've certainly heard compelling arguments for both interpretations, each drawing on specific, disturbing evidence from the material.
Indeed, the nuances here are significant, and it really highlights the challenge of discerning intent from structural vulnerability when the consequences are so incredibly severe.
And understanding these multiple perspectives is truly vital for anyone seeking to make sense of the situation in Canton Zug and indeed the broader Swiss child protection landscape. There is clearly much more to explore within this complex material.
Thank you both for this insightful and rigorous debate today.